आज हम डिस्कस करने जा रहे हैं कॉन्स्टिट्यूशन के उन प्रोविजंस के बारे में जिनके तहत भारत में पार्लियामेंट के और स्टेट में असेंबलीज के इलेक्शंस होते हैं। पहले मैं आप लोगों से क्षमा प्रार्थी हूँ कि थोड़ा आधे घंटे का डिले हो गया, क्योंकि मैं एडवोकेट मजूमदार साहब की वेट कर रहा था। अभी तक उन्होंने ज्वाइन नहीं किया है, हो सकता है कहीं बिजी हो, बाद में ज्वाइन करेंगे। तो ये जो इलेक्शंस इंडिया में होते हैं, जो भारत में होते हैं, उसका प्राविधान कॉन्स्टिट्यूशन में है और ये कॉन्स्टिट्यूशन के आर्टिकल 324 से लेकर के 329 के अंदर कवर होता है। चलो मजूमदार साहब आगे, मजूमदार को ले लेते हैं।
वेरी सॉरी सर, नमस्कार। बारिश में अटक गया था मैं सर, वेरी सॉरी।
मैंने वेट किया, मैंने कहा आधा घंटा हो गया, चलो अभी शुरू कर देते हैं, आप कहीं बिजी होंगे। Anyway, तो ये 324 से 329 के बीच में जो इलेक्शंस हैं वो कवर होते हैं आर्टिकल में। तो इलेक्शन कमीशन जो है इंडिया का, या जो स्टेट इलेक्शन कमीशंस हैं, वो सब इसी के अंदर में आते हैं। मैं एक आर्टिकल निकाला हूँ, लीगल सर्विस ऑफ इंडिया का है, उसको मैं शेयर करता हूँ और काफी मतलब अच्छा आर्टिकल मुझे लगा, इसीलिए मैं इसको शेयर कर रहा हूँ।
जी जी जी।
ये है वो आर्टिकल।
जी सर।
और इसमें ये हेडिंग ही दे रहा है इलेक्शन कमीशन ऑफ इंडिया, आर्टिकल 324 से 229।
जी सर।
अब ये क्या बोल रहे हैं कि इलेक्शन कमीशन ऑफ इंडिया इज एन ऑटोनोमस कॉन्स्टिट्यूशनल अथॉरिटी रिस्पांसिबल फॉर एडमिनिस्ट्रेटिंग इलेक्शन प्रोसेसेस इन इंडिया एट नेशनल, स्टेट एंड डिस्ट्रिक्ट लेवल। पढ़ लो।
The body administers elections to the Lok Sabha, Rajya Sabha, state legislative assemblies, state legislative councils, and the office of the president and vice president of the country. The Election Commission operates under the authority of the Constitution as per Article 324 and subsequently enacted Representation of People's Act of the People's Act. The Commission has the powers under the Constitution to act in an appropriate manner when the enacted laws make insufficient provisions to deal with a given situation in the conduct of an election. So the Commission has the powers under the Constitution to act in an appropriate manner when the enacted laws made are insufficient, have insufficient provisions to deal with a given situation in the conduct of an election.
तो यहाँ पर जो appropriate manner लिखा है, यहाँ पर उसको वाइड पावर दे दिया है, वो कुछ भी कर सकता है अगर लॉ नहीं है।
बिल्कुल सर। Being a constitutional authority, the Election Commission is amongst the few institutions which function with both autonomy and freedom, along with the country's higher judiciary, the Union Public Service Commission, and the Comptroller and Auditor General of India. So this commission stands on a high pedestal along with these authorities, the judiciary, the UPSC, the Comptroller and Auditor General. The commission was established in 1950
and originally CVC को ऑटोनोमस बोलते हैं, बट CVC का नाम नहीं है यहाँ पे। दैट मींस कॉन्स्टिट्यूशन में CVC का प्रोविजन नहीं है।
जी। The commission was established in 1950 and originally only had a chief election commissioner. 2 additional commissioners were appointed to the commission for the first time on 16th of October 1989 on the eve of the 1989 general elections, but they had a very short tenure ending on 1st of January 1990. The Election Commissioner Amendment Act 1989 was adopted on 1st of January 1990, which turned the commission into a multi-member body. A 3-member commission has been in operation since then, and the decisions by the commission are made by a majority vote. The chief election commissioner and the 2 election commissioners were... Yes, sir.
यहाँ पर मैं आपको बता देना चाहता हूँ कि ये जो 3 मेंबर जो कमीशन बना है ना, दैट वाज ओनली टू curtail the dictatorial attitude of Mr. टी.एन. सेशन। टी.एन. सेशन गुजरात कैडर के आईएएस ऑफिसर थे,
जी
और जब वो और गांधी के मतलब राजीव गांधी के बहुत क्लोज थे वो। तो जब 1991 के इलेक्शंस हो रहे थे, उसके पहले उन्होंने काफी कुछ बोला था कि भाई जो भी करना है मुझे करना है, ये करना है, वो करना है। तो उनको कंट्रोल करने के लिए वो एक और स्ट्रीम करेंगे टी.एन. सेशन के ऊपर, तो उसमें समझ में आएगा कि हाँ, उनको कंट्रोल करने के लिए एम.एस. गिल को और एक और कोई था, उनको बनाया गया था। एंड जब ये बनाया गया था तो बहुत नाराज हुआ था ये। ही वेंट अप टू सुप्रीम कोर्ट ऑल्सो कि भाई मेरे को अथॉरिटी है, कॉन्स्टिट्यूशन में ये है वो है। सुप्रीम कोर्ट ने बोला नहीं भाई, ऑटोनॉमस बॉडी है, और गवर्नमेंट अगर कोई एक्ट बना रही है तो आपको उसमें कुछ वो नहीं करना है। हाँ, बोलो।
G. The Chief Election Commissioner and the 2 election commissioners, who are actually retired IS officers, draw salaries and allowances at par with those of the judges of the Supreme Court of India, as per the Chief Election Commissioner and the other election commissioners conditions of service rules 1992. मतलब
वही,
उनके लिए
जब ये
अलग
टीएन सेशन को थोड़ा सा कंट्रोल किया था ना, तो उसमें रूल बनाए थे ये 1992 में।
जी 1992 में जी
हाँ।
सर। The commission is served by its secretariat located in New Delhi. The election commissioners are assisted by the deputy election commissioners, who are generally IS officers. They are further assisted by the directors general, principal secretaries and under secretaries. At the state election level, election commission is assisted by the chief electoral officer of the state, who is an IS officer of the principal secretary rank. At the district and constituency levels, the district magistrate, in their capacity as district election officers, electoral registration officers, and returning officers, perform election work. Part 15 of the Constitution, entitled as Elections, constitutes a code in itself, providing the groundwork for the enactment of appropriate laws and the setting up of suitable machinery for the conduct of elections. Then Article 324 Election Commission. Article 324 of the Constitution provides for the appointment of an election commission to superintendent, direct, and control the elections. The commission is an all India body having jurisdiction over elections to parliament, state legislatures, offices of the president and the vice president. The constitution of
अभी
one
देखो,
central
एक मिनट दादा,
जी
एक मिनट, यहाँ पर क्या
जी जी
बोल
जी
रहा है कि डिस्ट्रिक्ट लेवल की बात कर रहा था, ऊपर कहीं पर डिस्ट्रिक्ट लेवल की बात कर रहा था वो।
जी
स्टेट एंड ऑफिसेस ऑफ द दिस एंड द, क्या बोल रही है, लोकसभा, राज्यसभा, स्टेट लेजिस्लेचर असेंबली, स्टेट लेजिस्लेटिव काउंसिल एंड द ऑफिसेस। तो ये मत बोलना
हाँ
कि हाँ, स्टेट लेजिस्लेटिव काउंसिल्स के भी इलेक्शन यही करवाता है।
है ऊपर सेकंड लाइन में लिखा हुआ है प्रोसेसेस इन इंडिया इन फॉर एडमिनिस्ट्रेटिंग इलेक्शन प्रोसेसेस इन इंडिया एट द नेशनल स्टेट एंड डिस्ट्रिक्ट लेवल, यहाँ बोला है सर
ये
सेकंड लाइन में।
ये है ना,
जी जी जी
ये यहाँ गड़बड़ है।
गड़बड़ है क्योंकि स्टेट लेवल ही रहेगा।
हाँ। देखो ये बोल रहा है विच फीचर इज हेल्ड टू बी बेसिक स्ट्रक्चर ऑफ द कॉन्स्टिट्यूशन।
मैं पूरा ही पढ़ देता हूँ ना।
हम्म
The constitution of one central body, the election commission, having control over the entire election process in the country, is done to prevent injustice which could be done by regional state governments discriminating against any section of the people in the matters relating to elections. The commission is constituted as an autonomous and independent body with a view to ensure the conduct of free and fair elections, which feature is held to be a basic structure of the Constitution. It has been said to be the most important arbitrator on holding of elections. मतलब कोई dispute यदि election process में arise करे तो the election commission is the final authority
हम्म
to decide on that regard. Constitution of the Election Commission. Clause 2 of Article 324 provides that the Election Commission shall consist of the Chief Election Commissioner and such number of other election commissioners, if any, as the President may from time to time fix. Until Parliament makes any law in that behalf, the Chief Election Commissioner and other election commissioners are appointed by the President. When any other election commissioner is so appointed, the Chief Election Commissioner shall act as the chairman of the Election Commission. The President may also appoint, after consultation with the Election Commission, such regional commissioners as he may consider necessary to assist the Election Commission in the performance of its functions. The conditions of service and tenure of office of the election commissioners and the regional commissioners shall be such as the President may by rule determine. These rules, however, are subject to any law made by the Parliament in this respect. अब एक ये बता रहा है चीफ इलेक्शन कमिश्नर vis-a-vis other election commissioners. Proviso to clause 5 of Article 324 says that the chief election commissioner shall not be removed from his office except in like manner and on the like grounds as a judge of the Supreme Court. मतलब पार्लियामेंट में 2/3 मेजोरिटी चाहिए फिर
इम्पीचमेंट होगा वही
हाँ बिल्कुल impeachment and the conditions of service of the chief election commissioner shall not be varied to his disadvantage after his appointment. ये जज के लिए भी ये चीज applicable है.
हाँ
Thus it is clear that the election commissioners do not hold the same position as does the chief election commissioner.
बिकॉज कॉन्स्टिट्यूशन में सिर्फ इलेक्शन कमिश्नर की बात कर रहे हैं
कमीशन हाँ जी बिल्कुल चीफ इलेक्शन कमिश्नर को उस लेवल पे रखा गया है. While the chief election commissioner is the creation of the constitution, the number of other election commissioners is determined by the president. ये और clarify कर रहा है क्यों इसलिए because the others are determined by the president, but the chief election commissioner is the creation of the constitution. While the chief election commissioner can be removed from his office in the manner provided in the proviso to clause 5 of Article 324, the other commissioners hold their office during the pleasure of the president, subject to any law made by Parliament in this regard. Again, while the conditions of service of the chief election commissioner cannot be varied to his disadvantage, the conditions of service of other commissioners are determined by the president by rule, subject to any law made by the Parliament in this regard. थोड़ा सा डिस्टिंक्शन है जी द डिस्टिंक्शन को इन लोग क्लैरिफाई कर दिया. मल्टी मेंबर इलेक्शन कमीशन prompted by the Supreme Court's observation in S.S. Dhanwa's case and also in the wake of certain controversial decisions taken by the Chief Election Commissioner, जो आप बोल रहे थे, resulting in serious confrontation between the Commission and the Government of India, the latter, which means the Government of India decided to provide for a multi-member election commission. सेशन साहब का जो बोल रहे थे वही उसी का रेफरेंस नाम नहीं लेकर के इन लोग बता रहे हैं. For the purpose, the President promulgated the Chief Election Commissioner and other election commissions conditions of service amendment ordinance 1993 to amend the Chief Election Commissioner and other election commissioners conditions of service Act 1991. The ordinance was later replaced by the Act passed by the Parliament in 1994, which came into force on 1st of January 1994. The ordinance provided for a multi-member election commission, making the Chief Election Commissioner, placing the Chief Election Commissioner at par with other election commissions and providing that business of the commission would be transacted on the basis of unanimous decision and in case of difference of opinion on the basis of opinion of the majority. मतलब चीफ इलेक्शन कमिश्नर हैं, बाकी जो हैं the other election commissioners जी
धनोआ केस दिखा देते हैं जहां पे कंट्रोवर्सी हुई थी.
जी और इसमें यही बोल रहा है कि डिफरेंस ऑफ ओपिनियन होने से मेजॉरिटी जो राय मेजॉरिटी का राय प्रिवेल करेगी.
सेशन साहब को वही तो अच्छा नहीं लग रहा था ना.
जी जी, SS Dhanwa versus Union of India and others, 24th of July 1991. साइटेशंस दिया हुआ है, कहाँ कहाँ मतलब ये रिपोर्टेड है.
ये देखो, determination of number and appointment of election commission rule providing tenure of 5 years or up to
5 years.
subsequent notification by president abolition of the post of election commission whether nullified whether affect
Affect
independence of election commission material
lost to the incumbent.
एजेंसी. ठीक है.
जी जी.
हेड नोट. हेल्ड क्या किया इन लोगों ने? हेल्ड, हाँ ये हेल्ड.
The election commission as envisaged by the constitution is an independent institution and has to function as such. In the discharge of its duties and functions, it is not amenable to the control of any other body. The salient features of the composition of the election commission as given in article 324 of the constitution are that the commission shall always consist of a permanent incumbent, namely the chief election commissioner, but the president is also given the power to appoint such number of other election commissioners as he may from time to time fix. While the appointment of the chief election commissioner is a must, the appointment of other election commissioners
is not obligatory.
Not obligatory. The number of other is left. The number of other election commissioners is left to the discretion of the president, depending upon the need felt from time to time.
Now, discretion of the president means discretion of the government, union government.
Correct, sir. That the decision taken by the government will be assented to by the president. However, in the matter of the conditions of service and tenure of office of the election commissioner, जी वो नीचे पढ़ लिए हम लोग. रिलेशनशिप भी पढ़ लिए. इलेक्शन, हाँ, पेडेस्ट्रल के बाद देखिए उसका बात भी कर रहे हैं आगे.
The petitioner and the election commission were appointed when the work of the commission did not warrant their appointment. That the government had thought it fit to make the two appointment, although there was no need to do so. What other consideration weighed with the then government in making the appointment is anybody's guess, and the court does not propose to go into them. However, it was expected that the Union of India would candidly admit the initial mistake of making the said appointment rather than defend them. On
non-existent grounds. Not only there was no need for the said appointments, but also the appointments in the absence of the definition of the roles in the commission were creating an untoward and unworkable situation, rendering the commission internally torn and ineffectual in its functioning. The manner of appointment of the election commissioners and the attitude adopted by them in the discharge of their functions was hardly calculated to ensure free and independent functioning of the commission, much less its smooth working. This is the view of the court. In view of the fact that there was no need for the posts of election commissioners at the time of the appointments were made, and that in the absence of a clear definition of their role in the commission, particularly vis-a-vis the chief election commissioner, the appointments were an oddity. The abolition of the posts, far from striking at the independence of the commission, paved the way for its smooth and effective functioning. The instant case is not a case of a premature termination of service. It is a clear case of the abolition of the posts, and the termination of service is a consequence thereof. Hence, the termination of service is not open to challenge on the ground of any illegality. The removal of the election commissioners are not on the recommendation. एक और बता रहा, दूरदर्शन पे इन लोगों को दिखाया गया था, इनका फोटो वगैरह. कोर्ट बोल रहा है इट्स अनकॉल्ड फॉर.
Now let us see who was this fellow, the Nova.
Justice Sawant delivered this judgment.
Sawant, बहुत अच्छी जज थे. क्या हुआ? ये कैसे आया इसके पास धन्यवाद था? ये लिखते नहीं क्या लोग? कौन सा ये?
नहीं लिखा है शायद।
Who is
पिटिशनर पिटिशनर का बैकग्राउंड नहीं दिया है। ग्राउंड्स ऑफ अटैक स्ट्रेट अवे बोल रहा है। पिटिशनर का नाम धनवा ही होगा और श्री वी.एस.
अपॉइंटमेंट ऑफ
सहगल
petitioner and VS। अच्छा हाँ,
अपॉइंटमेंट।
वही
हाँ
ये इलेक्शन कमीशन अपॉइंट हुआ था, बराबर है, वही
हाँ,
धनोवा एंड
दो आदमी।
ये
जी
ये
जी
आए
जी।
थे, हाँ ठीक है।
पिटिशनर एंड वी.एस. शेरगिल,
हाँ
ये दोनों इलेक्शन कमिश्नर्स अपॉइंट हुए थे इन एडिशन टू द चीफ इलेक्शन कमिश्नर।
अब ये पढ़ लो थोड़ा सा। 8 देयर वाज
There is no doubt that two heads are better than one, and particularly when an institution like the Election Commission is entrusted with vital functions and is armed with exclusive and controlled power to execute them. It is both necessary and desirable that the powers are not exercised by one individual, however all wise he may be. It ill confirms the tenets of the democratic rule. It is true that the independence of an
यहाँ पे
institution.
सेशन को जूता मारा ना।
हाँ हाँ, बोल रहा है कि दो आदमी रहना ज्यादा बेहतर है इन अ डेमोक्रेटिक रूल रादर देन वन इंडिविजुअल।
नीचे पढ़ो, अ सिंगल इंडिविजुअल में
दो ही में भी ऑल वाइज, जूता तो दो ही में भी ऑल वाइज, देखिए ऑल वाइज ही में भी बोल रहा है। द इंडिपेंडेंस ऑफ एन इंस्टीट्यूशन डिपेंड्स ऑन द पर्सन्स who man it and not their number. A single individual may sometimes prove capable of withstanding all the pulls and pressures, which many may not. However, when vast powers are exercised by an institution which is accountable to none, because the Commission is accountable to none, it is politic to entrust its affairs to more hands than one. It helps to assure judiciousness and want of arbitrariness. यहाँ देखिए, it helps to assure judiciousness and want of arbitrariness. The fact, however, remains that where more individuals than one man and institution, their roles have to be clearly defined. If the functioning of the institution is not to come to a
हाँ,
knot.
ये है धनोवा का केस। ठीक है, अब फिर वापस चले जाते हैं अपने केस में।
जी,
मेहता जी बहुत क्या बोलते हैं, डेडिकेटेड हमारे व्यूवर हैं। ये आते हैं, कभी कभी कमेंट करते हैं और फिर निकल लेते हैं। The ordinance was later replaced by the Act Parliament 1994, which came into force in January so and so.
1st of January 1994. The
हाँ,
ordinance provided for a multi-member election commission, making the chief election commissioner ये होगा placing the chief election commissioner at par with the other election commissioners and providing that business of the commission would be transacted on the basis of unanimous decision and the case of difference of opinion on the basis of opinion of the majority following
yes,
the democratic process.
ये
अब
लो,
आ गया,
चलो
देखिए
इसको भी
आ
पढ़ते हैं।
गया।
टीम सेशन आगे
In
बढ़ते
TN Session versus Union of India, the Supreme Court unanimously upheld the constitutionality of the act, equating the status, powers, and authority of the two election commissioners with that of the chief election commissioner. The court held that the chief election commissioner did not enjoy a status superior to the other election commissioners, even though there were differences between the service conditions of the chief election commissioner and the other election commissioners. The scheme of Article 24, it was held, clearly provided for a multi-level body comprising of the chief election commissioner and other election commissioners.
हैं। टीएन
यहाँ
सेशन
तक
ढूंढ रहा हूँ, टीएन सेशन ढूंढ रहा हूँ,
हाँ,
एक मिनट।
जी जी जी।
किधर गया टीएन सेशन?
आ जाएगा सर।
नहीं आना चाहिए ना उसमें, वे कंप्लीट डॉक्यूमेंट में दिखेगा, इसमें आएगा लगता है। नहीं, इसमें नहीं है।
इंडिया कानून में तो मिल ही जाएगा सर।
वही इंडियन कानून में ढूंढ रहा हूँ, टीएन सेशन लिखा हुआ है ना मैंने ऊपर, सेशन की स्पेलिंग
जी जी
बराबर है
जी,
ना? हाँ
SESHAN।
हाँ, बराबर है।
ये तो दूसरी जगह मिल जाएगा सर, वैसे UOI।
इसमें है क्या, देखें?
हो, होगा तो जरूर सर, बहुत इम्पोर्टेंट केस है ये। इसका मेन
ये मिला, ये
बात
मिला, ये आ गया, आ गया।
सर, इसका मेन बात ये है कि द स्टेटस इज नॉट सुपीरियर, बट
टीएन सेशन वर्सेस ये आ गया, अहमदी
हाँ बट
जगदीश शरण वर्मा, एनपी सिंह, 5 का है, कॉन्स्टिट्यूशनल बेंच है।
जी, तो इसमें डिस्टिंक्शन ये है कि द इलेक्शन कमिश्नर्स have the same status as the chief election commissioner, but their service conditions are different.
अरे इसमें हेड नोट नहीं है भाई। हाँ, हेड नोट नहीं है, इसने ऐसे ही मार दिया। चलो लास्ट में देखते हैं क्या बोल रहा है फिर।
कंक्लूडिंग पैरा देख लेते हैं सर। ये तो
व्यूअर्स को अगर चाहिए तो ये अपना जजमेंट देख लेंगे, पढ़ लेंगे, ज्यादा अच्छा अपने को यहाँ पे पढ़ करके टाइम वेस्ट नहीं करना है।
जी जी,
ये जो है
मैं
ना
तो बता दिया सर एक ही लाइन में, मतलब द चीफ इलेक्शन कमिश्नर डज नॉट एंजॉय स्टेटस सुपीरियर टू द अदर्स, द इलेक्शन कमिश्नर्स,
ये
बट द
पढ़ लो
सर्विस
यहाँ से, नाउ इट
कंडीशंस में बी
इज
डिफरेंट।
है, ये वाला पढ़
जी,
लो। ये
इंडिपेंडेंस ऑफ इलेक्शन कमीशन।
कहाँ से पढ़ेंगे, एक मिनट, इसमें पैरा नंबर भी नहीं दिए इन्होंने यार।
ठीक है सर, इसका अलग करेंगे, उस समय देख लेंगे हम लोग। मेन
Now
कोर्ट
it
का
must be
जो
noted that outside the both clauses 2 and 5 contemplate a statute for the appointment of election commissioner and their condition. The impugn law provide for both these matters and provision to that effect cannot be challenged as unconstitutional, na?
जी जी
Since they are expressly permitted by the said clauses 2 and 5. Once the provision for the constitution of multi-member measure is unassailable, provisions incidental thereto cannot be challenged. Okay, okay. If, as argued, the scope of this entry is relatable and confined to class 2 and 5 of Article 34 and Article 327 and 3 only, it would be mere tautology. If the contention that the CEC alone has decisive power is not accepted, and we have not accepted it, and even if it is assumed that the normal rule is unanimity, subsection 1 and 2 of section 10 provide for unanimity. It is only if there is no unanimity that the rule of majority comes into play under subsection 3. Therefore, even if we are to assume that commission alone was competent to lay down how it would transact its business, it would be required to follow the same pattern as it sets out in section T. We would here like to make it clear that we should not be understood to approve the ratio of the Nova case in its entirety. We have expressly approved it where required. One of the matter in which we adverted is question of this, but that अरे बाप
नहीं समझ में आ गया सर। दे हैव मेड अ डिस्टिंक्शन बिटवीन द धनवा केस एंड TN Session केस।
रे। Yes.
In that, they are in this particular case of TN Session, they are saying the scheme of Article 324 provides a multi-member body comprising the Chief Election Commissioner and other election commissioners. But the question was whether the Chief Election Commissioner enjoys a status superior to the others. But the court said no, they have the same status, powers, and authority, the three of them, but the service conditions are different.
ते पढ़ो तो।
That सर दिखाई
Delegation
नहीं
of
दे
the
रहा,
arranged by Krishnamurti and Gill.
दिखाई नहीं दे रहा है सर।
अच्छा मैं वो करता हूँ। हाँ लो, द एलिगेशन, यहाँ से दीज एलिगेशंस दिख रहे हैं?
नहीं सर, वो अभी तक वो है, पुराना वाला है ना अपना आर्टिकल।
एक मिनट, मैं उसको ला रहा हूँ, सेशन वाले को ला रहा हूँ, एक मिनट।
जी जी जी।
आया?
G. We have deliberately avoided going into the unpleasant exchanges that took place in the chamber of the Chief Election Commissioner on 11th of October 1993, to which reference has been made by the Chief Election Commissioner in paragraph 18, C to F and G of his petition. These allegations have been denied by Sri Krishnamurti and Sri Gill. Does not support the Chief Election Commissioner when he says he was abused. Although these allegations and counter allegations found their way into the press, we do not think any useful purpose will be served by washing dirty linen in public, except showing both the Chief Election Commissioner and Sri Krishnamurti in poor light. The Chief Election Commissioner and the election commissioners are high level functionaries. They have several years of experience of civil servants behind them. All of them have served in a responsible position at different levels. It is a pity that they did not try to work as a team. The efforts of Shri Gill to persuade the other two to forget the past and to get going with the job fell on deaf ears. Unfortunately, suspicion and distrust got the better of them. We hope they will not forget. We hope they will forget and forgive. Start on a clean state of mutual respect and confidence and get going with the task entrusted to them in a sporting spirit, always bearing in mind the fact that the people of this great country are watching them with expectation. For the sake of the people and the country, we do hope they will eschew their egos and work in a spirit of camaraderie. In the result, we uphold the impugned ordinance, now Act 4 of 1994 in its entirety. We also uphold the two impugned notifications, impugned matlab, those under challenge, notifications dated 1st of October 1993. Hence, the petitions fail and are dismissed. The interim order dated 15th of November 1993 will stand vacated. If, as is reported, the incumbent Chief Election Commissioner has proceeded on leave, leaving the office in charge of Sri Bagga, Sri Bagga will forthwith hand over charge to Sri Gill till the Chief Election Commissioner resumes duty. That ये application, the
ट्रांसफर एप्लीकेशन है ये।
transfer applications will stand disposed of. In the facts and circumstances of the case, we direct the parties to bear their own costs. If the Chief Election Commissioner has incurred the costs of his petition from the funds of the Election Commission, the other two election commissioners will be entitled to the same from the same source.
गुड। चलो आ जाओ, इलेक्शन कमीशन के जल्दी से पढ़ लेते हैं। उधर से
जी
राहुल साहब बोल रहे हैं जल्दी शुरू करो दूसरी वाली।
जी कर देते हैं सर।
एक मिनट, इसको खत्म कर देते हैं, फिर आ जाते हैं।
The Election Commission generally has a few staff. Acha, independence of the Election Commission. The Constitution envisages the setting up of an independent autonomous election commission to secure independence of action. Article 324 contains the following provisions: that the Chief Election Commissioner shall not be removed from his office except in the like manner on the like grounds as a judge of the Supreme Court, that the conditions of service of the Chief Election Commissioner shall not be varied to his disadvantage after his appointment. ये तो हम लोग पढ़ लिए हैं सर पहले. The Chief Election Commissioner is therefore protected against political, ये ठीक है सर, इसको थोड़ा पढ़ लेते हैं. Protected against political and executive influence, ये important है. The Chief Election Commissioner is therefore protected against political and executive influence, and for that reason he can discharge his functions without favor or pressure from the executive or the
सवाल
party
ये
in
उठता
power.
है दादा,
जी
Chief Election Commission is protected, is all right, but what about election, state election commission?
हाँ, तो
He's
वही
not
तो मैं बोल
protected
रहा
ना।
हूँ, अभी बंगाल का हाल देखिए क्या हुआ।
वहां तो पॉलिटिकली इन्फ्लुएंस हो जाता है ना फिर आदमी।
बिल्कुल बिल्कुल।
अगर
इवन
इनको
द
वही करना है तो कॉन्स्टिट्यूशन में अमेंडमेंट करके स्टेट इलेक्शन कमिश्नर को भी वो कर दो, प्रोटेक्ट कर दो। फिर देखो कैसे ममता बनर्जी को
अपने आप
बुझाते हैं
सीधा,
लोग।
जी अपने आप फेयर एंड फ्री एंड फेयर इलेक्शंस होंगे फिर। Even the tenure of office of the other election commissioners and the regional election commissioners are also free of the executive control insofar as none of them can be removed from office. देखिए, insofar as none of them can be removed from office except on the recommendation of the chief election commissioner. ये कोई मतलब important कोई check and balance नहीं है।
फंक्शन ऑफ इलेक्शन कमीशन ठीक है, वो
हाँ।
वोटिंग लिस्ट बनाएंगे और ये करते हैं।
Superintendents, preparing of electoral rolls, conduct of elections, advising the president and governor of the state in connection therewith.
सुपरिटेंडेंट की बात हो गई। फिक्सिंग शेड्यूल फॉर इलेक्शन, हाँ इलेक्शन की डेट अनाउंस करेंगे।
The apex court in special reference number 1 of 2002 was referred to questions relating to the powers of the election commission under article 324, fixing the schedule for holding elections to the legislative assembly of a state in the light of the mandate of article 174 clause 1. The question cropped up out of the situation then existing in the state of Gujarat. The legislative assembly of the state, which was to complete its term on 18th of March 2003, was dissolved on 19th of July 2002 by the governor on being advised by the chief minister. Since the last sitting of the assembly was held on 3rd of April 2002, the Election Commission was required to complete the elections to the assembly by that date so as to comply with Article 174 Clause 1 mandate. The Election Commission on its part recommended the invocation of Article 356 in the state, as the situation in the state, in their opinion, was not suitable to hold early, free and fair elections so as to comply with the requirement of Article 174 Clause 1. ये 42 अलग चीज है सर।
42 मतलब वो है, 42 जो रेफरेंस दिया होगा ना नीचे,
हाँ, रेफरेंस नीचे दिया हुआ है।
नोट में दिया होगा ना, इसके लिए है।
सर यहाँ तो गुजरात के विषय में ऐसा बोल रहा है कि फ्री फेयर नहीं होगा इसीलिए टाल दिया गया, तो यहाँ बंगाल के टाइम मतलब कुछ नहीं किया है सब। अभी जो हुआ है बंगाल में, वहां तो कुछ नहीं किया है सब, सोचा भी नहीं फ्री होगा फेयर होगा। फेयर तो हुआ ही नहीं है, फ्री एंड फेयर कहाँ हुआ।
नरेंद्र मोदी
कॉन्स्टिट्यूशन
गवर्नमेंट थी ना, उसको इसके लिए सुप्रीम कोर्ट में चले गए थे, तो वहां पर उन्होंने डायरेक्शन पास कर दिया। ममता बनर्जी के खिलाफ कोई गया भी तो मानती कहाँ है वो।
The Constitution bench of the 5 judges of the Supreme Court answering the questions set out in the reference reported as follows. Article 174 Clause 1 is a complete code in itself, deals only with a live legislature. Article 174 Clause 1 does not provide for any period of limitation for holding elections within 6 months from the date of the last sitting of the session of the dissolved assembly. There is no problem expressly provided for any period of limitation for constitution.
लंबा कर रहे हो, जाने दो, किसी को पढ़ना में पढ़ लेंगे वो लोग अपन।
System of adult suffrage.
हाँ,
Votes on this. अच्छा,
325
one
electoral
electoral
pass
roll
कर
for
रहे हैं।
every constituency. There will be only single roll for every constituency. One electoral general electoral roll. That is okay, sir. Then system
326 is adult, 18 साल।
adult suffrage means voting rights किसका है? He or she must be a citizen of India. He or she must not be less than 18 years of age. He or she must not be otherwise disqualified under the constitution or any law made by the appropriate legislature on the ground of non-residence, unsoundness of mind, crime, corrupt or illegal practice. तो क्रिमिनल तो वोट दे ही रहा है।
राइट भी ले लेते हैं इनका, बिकॉज ऑफ क्रिमिनल से करप्ट किस वजह से,
यहाँ तो लिख रहा है, लेकिन
वोटिंग राइट कहाँ जाता है? लालू को किधर गया वोटिंग राइट?
हाँ वही तो मैं बोल रहा हूँ, डिस्क्वालिफिकेशन कहाँ किया गया? लालू क्या मतलब मोहल्ले में सब घूम रहे हैं क्रिमिनल,
हाँ,
पार्लियामेंट है।
बड़े लोगों की बात कर रहा हूँ। मुख्तार अंसारी है, अतीक तो
हाँ
मर गया
हाँ
है।
हाँ, राइट टू वोट इज नॉट अ फंडामेंटल राइट, ये इम्पोर्टेंट है सर।
हम्म,
Though it is important in a democracy, though fundamental to democracy, the right to elect is neither a fundamental right nor a common law right. So the right to be elected and the right to dispute an election. So is the right to get elected or be elected, and the right to dispute an election. Enactment with laws with respect to elections. Article 327 provided.
327 पार्लियामेंट के लिए होगा मेरे ख्याल में, 328 स्टेट
हाँ
के लिए होगा।
हाँ जी जी जी, House
इलेक्शन
of Parliament and Legislatures, election disputes.
लिमिटेशन, ठीक है। इलेक्शन कमीशन इज टू एक्ट इनकंसिस्टेंट विद, ठीक है। सेटलमेंट ऑफ डिस्प्यूट, ये अच्छा।
Election disputes.
हम्म,
Clause A of Article 329 provides that the validity of any law relating to delimitation of constituencies or the allotment of seats to such constituencies made or purported to be made under Article 327 or 328 shall not be called in question in any court. Clause B of Article 329, as amended by the Constitution 19th Amendment Act 1966, provides that notwithstanding anything in the Constitution, no election to either House of Parliament or the legislature of a state shall be called in question except by an election petition presented to such authority and in such manner as may be provided for or under any law made by the appropriate legislation. In pursuance of this clause, Parliament enacted the Representation of Peoples Act 1951. The act has vested the power to decide any election petition in the high courts. ये important है, क्यों जाता है हाई कोर्ट में? इलेक्शन में कहीं गड़बड़ी होती है तो लोग हाई कोर्ट क्यों जाते हैं? तो दिस प्रोविजन इज देयर. The Act, Representation of Peoples Act 1951, has vested the power of deciding on election petitions in the high courts. And K. Venkatachalam versus A. Swamikan. The Supreme Court in this case has ruled that Article 329B does not come into play when the case falls under Article 191 and Article 193. The word election is held to include every process of proceedings after issuance of election notification.
वेरी इंपॉर्टेंट, यस।
इलेक्शन नोटिफिकेशन के बाद जो भी कार्रवाई किया जाए, मतलब एनी प्रोसेस ऑफ प्रोसीडिंग्स, दैट विल ऑल कम अंडर द वर्ड इलेक्शन. फिर इंद्रजीत बरवा वर्सेस इलेक्शन कमीशन ऑफ इंडिया, it was held that preparation of electoral rolls was not part of election. ये तो पहले ही होता है. It was further said that no election could be challenged on the ground of defect in electoral rolls. The court ruled that an election could be challenged only by an election petition as required by Clause B of Article 329. Any alleged illegality or irregularity in the matter relating to allotment of a symbol can only be challenged by filing a petition on any of the grounds under Section 100 of the Representation of Peoples Act 1951, read with Article 329B of the Constitution, after the election process is over, not at the intermediate stage by filing a writ petition. देखिए यहाँ important चीज है सर, after the election process is over.
You cannot stall the election process ना, idea
हाँ
is that.
इसीलिए मैं
हरिशंकर
फिर
जैन, हरिशंकर ये जो
वर्सेस सोनिया
विष्णु जैन का
गांधी. हाँ
पिताजी हैं, ये क्या
हाँ
बोल रहे हैं?
पिताजी जी, विष्णु जैन के पिताजी हैं. द
बोलो।
सुप्रीम कोर्ट हैज रूल्ड that in spite of a person having been enrolled in the voters list, the question whether he is a citizen of India hence qualified for or disqualified from contesting an election can be raised before and tried by the High Court hearing an election petition.
डायरेक्ट सुप्रीम कोर्ट में पहुंच गया था लगता है, इसके लिए हुआ होगा।
जी जी जी.
अटल बिहारी वाजपेयी क्या बोले? Duly
As
nominated
regards,
candidate could file the petition by mere filing nomination paper. अच्छा, he cannot file.
person does not become duly nominated
हाँ,
candidate.
he has to contest. He has to contest.
Definitely. Then he has to file affidavits. The word candidate does not include a candidate who has withdrawn his candidature. This is okay, sir. फिर मंडा Jagannath versus KS Ratnam. the nomination form be filed by the respondent was rejected by the returning officer. Whether the returning officer was justified in doing so was held to be a matter to be agitated in an election petition only and not before the High Court under Article 226.
ये कौन सा आर्टिकल उठा,
ये क्यों डाला?
क्या कर रहा था ये?
ये क्यों डाला?
1419 इसका इफेक्ट हो रहा था क्या? कुछ भी
इसमें
करते हैं लोग।
1419 का इफेक्ट तो है ही नहीं इसमें।
और वो भी सुप्रीम कोर्ट में, मतलब क्या मार खाने के लिए गए थे ये लोग, कुछ भी करते हैं यार।
अरे चला गया, प्रोविजन है केस फाइल करने का, चला गया।
पैसा मिला होगा ना बंदे को।
Any challenge to an election once the election is over can be taken by an election petition.
firm view that if an advocate or a senior counsel argues something which is not as per the constitution or as per the law, something should be done against that advocate also.
Now it's being done. Nowadays it's being done. Exemplary cost.
The cost should not be imposed on the petitioner. Cost should be imposed on the advocate.
नहीं तो हमारे यहाँ तो वही कर रहा है ना आजकल, हमारे यहाँ वही कर रहा है. The cost has to be borne by the advocate. Either he has to contribute to the bar council, this thing, advocates relief fund, or has to deposit the money somewhere else in some other way.
क्योंकि उसकी गलती तो नहीं है ना,
बिल्कुल, क्लाइंट को क्या मालूम है. Delimitation is supposed to take every 10 years. It is done by the Delimitation Commission. The Constitution 84th Amendment Act 1976 freezed it till 2001. There have been 3 delimitation commissions in 1952, 1963 and 1973 before the present commission appointed in 2002 with Justice Kuldeep Singh as its chairman.
इसके बाद delimitation हुआ ही नहीं. Clearly, there is an excess constitutional bar to any challenge being made to the delimitation law, which is made under constitutional provision. Therefore, the substantial challenge of the appellant in this proceeding is not to be entertained by any court, including this court.
This court मतलब को वो तो सुप्रीम कोर्ट चला गया था ना.
सबको बोल दिया, और कहीं नहीं जाना है.
पैंथर पार्टी का देखिए, पैंथर पार्टी का चीफ भीम सिंह.
हाँ. ये लोग कुछ भी करते हैं. Court explained that right to cast vote was a valuable right, but to demand any value of one voting right through the process.
Delimitation disregarding the statutory and constitutional dispensation based on historical reasons. Based on historical reasons, देखिए, based on historical reasons was not a justiciable right. सही बोला.
Yes, चलो ठीक है, फिनिश करते हैं इसको.
जी सर, जी सर.
So,
सॉरी सर, फिर से क्षमा चाहता हूँ कि थोड़ा लेट हो गया.
इलेक्शन के बारे में कॉन्स्टिट्यूशन के जो प्रोविजन थे उसकी ये लाइव स्ट्रीम खत्म हो रही है. आप लोगों को अगर ये स्ट्रीम अच्छी लगी हो, अगर ये वीडियो अच्छा लगा हो, तो इसको लाइक करें और सोशल मीडिया में अपने दोस्तों यारों के साथ में शेयर करें. काफी नॉलेज मिलेगी और जो नहीं हम लोगों ने कवर किया है वो आप कॉन्स्टिट्यूशन में जाकर के 324 से 329 के बीच में पढ़ सकते हैं. 329A जो मैंने लिखा है उसको, वो उसमें क्या बोलते हैं, जब 42nd कॉन्स्टिट्यूशनल अमेंडमेंट हुआ था इमरजेंसी टाइम में, उसको बाद में 43rd में या 44 में उसको हटा दिया गया था. उसमें यही था कि इलेक्शन ऑफ प्रेसिडेंट, वाइस प्रेसिडेंट एंड प्राइम मिनिस्टर कैन नॉट बी चैलेंज्ड, तो वो हटा दिया गया है. तो उसके बारे में मैं ज्यादा बोलना नहीं चाहता. आप लोगों का बहुत बहुत धन्यवाद. जय हिंद, जय भारत, भारत माता की जय. नमस्कार.
जी, भारत माता की जय. वंदे मातरम. थैंक यू सर.